Good afternoon, everyone. My name is Cheyenne Exley, and I'm the program coordinator for the Moot Court program. This is the championship round for the 2023 Moot Court State Championship. Before we begin, we would like to thank our sponsors who made today possible. OCLRE is sponsored by the Supreme Court of Ohio, the Office of the Ohio Attorney General, the Ohio State Bar Association, and the ACLU of Ohio Foundation. Moot Court is also made possible through a grant support of the Ohio State Bar Foundation. In a moment, I will have the judges introduce themselves, followed by the students, and then we will begin the hearing. Arguments in the championship round will last 1 hour, excluding introductions and feedback. These two teams have fought through 4 preliminary rounds, followed by a semifinal. I am looking forward to seeing your hard work pay off. At this time, I will hand it over to the judges to give their introductions and to start us off. Thank you.
Thank you. Good morning, or afternoon, I guess it is. How are you all today? You having fun yet? Yeah, right. My name is Pat Fisher. I'm a justice of the Ohio Supreme Court. I guess other than the Chief Justice, I'm the most senior. And I was, before that, I was an appellate judge in Cincinnati at the First District Court of Appeals, and before that, 23 years at the law firm of Keating, Meath, and Kleekamp, where I tried cases throughout the country. 1 million frequent flyer points, something like that. Judge Tracy.
Hi, I'm Ben Tracy. I am a senior judicial attorney at the Ohio Supreme Court. I work for Justice Jennifer Bruner. I'm delighted to be here with you all today. Before I was in my current position, I was with the 10th District Court of Appeals, and prior to that, I was a federal law clerk and civil rights attorney.
Judge Jacobus.
Hi, my name is Gina Jacobus. I work at the Ohio Attorney General's Office. I'm the Assistant Section Chief of the Court of Claims Defense, which is a court actually in this building that handles cases involving defendants being state agencies, universities, departments, and that sort of thing. So, and we handle our own appellate work, and I argue in front of the 10th District.
Judge Cox.
I'm Paul Cox. I'm a retired attorney in Columbus. For 40 years, I was chief counsel of the Ohio State Fraternal Order of Police.
Judge Dodderman.
Steve Dodderman. I'm a regional fiduciary executive and attorney at Fifth Third Bank. Have been in the wealth management area at Fifth Third Bank since 1979. And currently, I am president of the Board of Trustees of the Ohio Center for Law-Related Education, OCLRE.
Thank you all for being here. I guess we asked for openings by petitioner A1.
May I briefly introduce myself?
Please, please.
Good afternoon, Your Honors. My name is Minda Bates, and my student code is A1. I will be presenting the appellate's argument for the first question in today's case. This is my co-counsel, Nora Holbrook. Her student code is A2, and she will be presenting the appellant's argument for the second question in today's case.
Good afternoon, Your Honors.
Thank you. Team D.
Good afternoon, Your Honors. My name is Sylvia Corson, student code D3, and I will be addressing issue 1 for the respondent. This is my co-counsel, Hannah Madison, student code D4, and she will be addressing issue 2.
All 4 of you got the memo. Black is good. Ready to begin?
Yes, Your Honor.
Please start.
Good afternoon, Your Honors. I would just like to remind you that my name is Minda Bates, my student code is A1, and I'll be representing the appellate's argument for the first question. Chief Justice, Your Honors, may it please the court. The first question is whether the search of the vehicle Austin Jones was driving was constitutional under the Buckeye Constitution's 4th Amendment. We answer this question in the negative. The 4th Amendment to the Buckeye Constitution reads in pertinent part, quote, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, but upon
probable cause, end quote. So what is probable cause? The Supreme Court held in Carroll v. United States that probable cause exists, quote, if the facts and circumstances before the officer are such as to warrant a man of prudence and caution and believing that the offense has been committed, end quote. The state had the burden in our case, and they have failed to prove that the smell of marijuana emanating from Jones's vehicle provided probable cause to conduct the search. First, the smell of marijuana did not provide probable cause to search the vehicle.
Why?
Excellent question.
That's why I asked it.
So in the state of Buckeye, the possession and use of marijuana is no longer illegal per se. While there are limitations, such as the use of the marijuana, burning marijuana, and the level of THC an individual possesses at a given time, it cannot be determined if those limitations have been surpassed simply based on a stale stench of marijuana.
Counsel, isn't it true, though, that if a person were under the influence of marijuana while driving, there could be an offense?
There was no evidence that the defendant in our case was under the influence of marijuana.
This was such a strong smell, though. How could the officer reasonably have been expected to ignore it?
We would disagree that it was a strong smell, and in fact, the facts of the case would also disagree that it was a strong smell of marijuana. In fact, the officer described the smell of marijuana to be ancient and even to be masked by other smells, such as Doritos, Funyuns, and other questionable stenches. And furthermore,
Would those stenches infer that marijuana was being used? People eating?
the officer cannot conclude that at the time of the search. It would be unreasonable. And furthermore, the officer had an entire conversation with Jones, with the windows rolled down, face to face with Jones, before he even noticed the stale, ancient smell of marijuana. And it was only after, supposedly, the wind changed that blew the stench of stale marijuana towards the officer that he even noticed that, quote, it smelled a little like pot. Therefore, the smell of marijuana was not powerful and did not justify the search. Now, in fact, several other states that have legalized medicinal marijuana, such as Massachusetts and Pennsylvania, have held in cases such as Massachusetts v. Overmeyer and Pennsylvania v. Barr that the smell of marijuana alone no longer constitutes a specific fact suggesting criminality. Furthermore, the Supreme Court of Michigan held in Michigan v. Armstrong that while the smell of marijuana may be a factor in establishing probable cause for a search, it cannot be the sole basis for probable cause to justify a search.
But those cases aren't controlling precedent for this court, are they?
This is a unique issue since it is a rather modern issue. While we do agree that since these come from other state courts, they don't take precedent and are simply persuasive. Since this is a modern issue and since these cases come from the late 2010s and early 2020s, and since this is a state issue, we agree that they hold more weight to this case.
Counsel, would you agree that a point of distinction in this case is that there was a smell of burned marijuana and that under the Buckeye medical marijuana statutes, even if you have a license to possess and use marijuana, you are nonetheless not allowed to smoke it?
Absolutely, Your Honor. However, in the Supreme Court case California v. Acevedo, the court held that the smell of legal vaporized medicinal marijuana and the smell of illegally burnt marijuana have the same stench. And the court held that an officer, no matter their training, cannot distinguish if the stench of marijuana is coming from legally vaporized marijuana or coming from illegally burned marijuana. Hence why these cases held that the smell of burning marijuana alone does not constitute probable cause to search the vehicle. Now, finally, the Supreme Court of Ohio specifically stated in Ohio v. Ferris that the, quote, odor of burnt marijuana in a passenger compartment of a vehicle does not standing alone establish probable cause for a warrantless search of the trunk of the vehicle, end quote. Now, once again, in our case, the only factor that the officer based his search on was the smell of marijuana that he did not even immediately notice. Now, assuming arguendo that there was probable cause to search the immediate area of the vehicle, there was still no probable cause established that permitted the officer to search the trunk, and even further, the sealed pinata within the trunk of Jones's vehicle. In the state of Buckeye, it is illegal to possess burning marijuana, as Your Honor stated, or to surpass a certain amount of marijuana or THC. Now, the officer found no evidence of burning marijuana in the front or rear seats of the vehicle. The officer must have believed he was going to find burning marijuana in the trunk of the vehicle that was not even accessible to Jones at the time of the traffic stop.
Why was it not accessible?
The facts stipulate that there was no evidence that Jones could reach the trunk from within the passenger compartment of the vehicle. The model of the vehicle in today's case is a Buick LeSabre, which has the trunk as a completely separate compartment of the vehicle. It does not allow the seats to fold down. There's no window peering into the trunk. It is a completely separate compartment that Jones could not access. Now, regarding the issue of the amount of marijuana the officer believed Jones to be in possession of, the Supreme Court of Massachusetts held in Overmeyer that an odor of marijuana does not mean that the vehicle contains a criminal amount of contraband. An officer, no matter their training, cannot tell, simply based on an old smell of marijuana, how much unburnt marijuana an individual may or may not be in possession of.
So, counsel, are you saying that, assuming arguendo, there's probable cause to search the vehicle, once the officer searches the vehicle, does not find marijuana, he's not entitled to then search another container, namely the trunk, and another container, namely the pinata, in which that marijuana could have been stored?
Correct. To
Why
allow.
not? Help me understand.
If we allowed the officer to continue his search, we have to ask where the limit would be. If just because the officer smells an old stench of marijuana, does that mean that the officer can then search the defendant's home if he doesn't find marijuana in the vehicle? If he doesn't find marijuana in the immediate passenger compartment, that does not mean that he's able to then search the trunk or search sealed compartments in the vehicle or go beyond that and search his home. There has to be a limit.
The trunk's different from a home, though, right? The home's not going to run away while the officer goes and gets a warrant if he can. The trunk, however, is attached to the car, and the car, of course, can move, and that's why we have a warrant exception for vehicles, is it not?
However, we are contending that the trunk is a completely separate compartment and even can be compared.
Did the officer know that at the time? Is it stipulated that the officer knew that the trunk was separate?
He could conclude that based on the model of the vehicle.
But there's nothing in the record to show he knew that.
Correct, but there's also nothing that says that he knew if Jones could access that.
Would it make a difference if the facts laid out that the officer accessed the trunk through the back seat by pulling the seats down as opposed to opening the trunk through the back?
Again, based on the design of the vehicle, it would not be possible for the officer to do that. We're arguing that the trunk is a completely separate compartment to the rest of the vehicle, and the automobile exception does not extend to that.
So now we have to worry about what the model of the vehicle is and whether or not the trunk is accessible through the back seat?
That's correct. If we allow an officer to search every sealed compartment within the car, then why do we have the Fourth Amendment? Its protections are meaningless. There has to be control on what the officer is not allowed to search.
So somebody who has a vehicle whose trunk is not accessible through the back seat has greater Fourth Amendment protections than somebody who has a vehicle whose trunk is accessible through the back seat.
Not necessarily, Your Honor, because at that point we argue that the officer could simply get a warrant to search the vehicle. If he takes the time to deliberate what kind of vehicle it is, then he could simply receive a warrant to search the vehicle. Furthermore, there was no probable cause to search the pinata within the trunk of the automobile. The Supreme Court in California v. Acevedo held that the scope of a warrantless search of an automobile is defined by the object of the search and the places in which there is probable cause to believe that it may be found. And
Here we're talking about smell, correct?
that is correct.
If the smell is coming out of the pinata, why not open the pinata?
The officer could not conclude if the smell was coming from the pinata.
Why not?
Since the officer cannot conclude where the stench was coming from, if it was coming from the passenger compartment, the courts held in Pennsylvania v. Barr in Overmeyer that an officer cannot tell where the stench is coming from and how much marijuana is present. And quickly, Your Honors, I realize my mistake. I refrain from reserving 2 minutes of my time for rebuttal. I would like to do that now if it's admissible to Your Honors.
That's fine.
Thank you. Now, when applying this to the facts of our case, the object of the search was burning marijuana, and the officer somehow concluded that a closed pinata that he had to tear open was an entirely separate compartment. I realize I am out of time, Your Honors. That is my apology.
Thank you.
May I briefly conclude?
Sure.
It is for these reasons the appellant respectfully requests that you reverse and remand the lower court's decision.
Thank you.
Thank you.
Please.
May I proceed?
Yes, please.
Before I begin, I would like to reintroduce myself. My name is Nora Holbrook, and my code is A2.
Thank you.
Chief Justice, Your Honors, may it please the court. Today, I'll be presenting the appellant's argument for the second question. What amount of marijuana did Jones possess, and what consequent level of offense, if any, should Jones have been charged with or indicted for? Under the Buckeye Code, Jones was in possession of hemp, not marijuana. Therefore, no charges are applicable. Austin Jones was found to be in possession of THC-infused chocolate during an unconstitutional search of the car he was operating. The state contends that Jones was in possession of 1,125 grams of marijuana in violation of Buckeye Code 2925.11 C3D, which states, if the amount of the drug involves equal or exceeds 1,000 grams, but is less than 5,000, the possession of marijuana is a felony of the third degree. Jones was only in possession of hemp. Even if this were not to be considered a hemp product, it would still fall under the definition of food under the definition of drug. And finally, counting the weight of the chocolate as towards the weight of the drug involved would make it absurd. The chocolates Jones possessed contained only 2.5 grams of THC with over 1,100 grams of chocolate. Under the Buckeye Code, the chocolates would fall under the definition of hemp due to the low THC levels present within the chocolate.
Counselor, I don't understand the difference. To be able to enjoy the product, one must eat the entire piece of chocolate. So what's the difference? What's the difference whether it's just a tiny amount, you have to eat the whole thing, and the statute seems to be based on weight, total weight.
To reach the statute of hemp, you have to have less than 0.3% of THC to get to the hemp definition. And in our case, we did have 0.22% THC diluted between the whole 250 pieces of chocolate. In the definition of hemp, it does not care on the intent of what the chocolate was used for. The statute is clear. If it was below the 0.3%, it would be considered hemp and is unregulated in the state of Buckeye.
Counsel, are we taking the label of the chocolate, giving it a little bit too much weight? I mean, the manufacturer of that chocolate could always say that the percentage was under 0.3, and therefore, all of its chocolate that it produces is under the limit or over the limit for being considered hemp. I mean, if we're parsing out the what's making up the chocolate, now do we have to, get a crime lab involved every time that they see something? Because we won't know the concentration of the THC in the chocolate.
Your Honor, since the information and the ingredients list on the back of the chocolate is the only information we have on what was actually inside the chocolates, we would have to give it more weight in our case, since the state is using also the nutrition's list to come to the 1,125 grams, which they're trying to charge our client with. We are just using the same exact list and doing the math to come to our conclusion.
Right, but wouldn't the more logical way for the state to figure out how much is contained within that piece of chocolate, assume it didn't have a label at all, the state wouldn't know how much THC is in that piece of chocolate. The only thing it could do would be to weigh the chocolate. And so now if we have to parse out what the ingredients are, we have to rely on a label. But what if there's not a label? Then how does that help your case, your client?
Yes, Your Honor. Under the definition of drug, the statute that they're trying to charge a client with today says that the weight of what they're charging you with is the drug involved. And if you look at the definition of drug, it excludes food. So if the substance that the THC was mixed with was food, then we would not be able to count that in the weight to charge Austin Jones with the crime.
But is this really intended to be food?
Yes, Your Honor.
You consider, the purpose of this is not for nourishment, is it? It's really just to get a little buzz.
Your Honor, under the definition of hemp, we do not get to the point where we have to look at the intent of what the chocolate was being used for. If the threshold is, if it's under 0.3%, it would be hemp. And under the definition of hemp products, food for consumption would be considered in that definition.
Is there a limit to the principle of your argument? I mean, if I took a very small amount of marijuana and I sank it into 100 pounds of chocolate, does that just automatically convert that piece of marijuana into hemp? Like it's marijuana here and then I drop it in, the chocolate hardens and now it's hemp?
We have to look at what the weight of the THC within the marijuana was, and if it was under that 0.3%, it would be considered hemp. If it was above it, it would be marijuana.
And so what if in aid of my drug smuggling, I got a baggie of marijuana and I hid it in a large quantity of, let's say, rice. Now it's a mixture of rice and marijuana, and even though I can go retrieve the marijuana later, if I get stopped by the police, I can say, no, that's hemp, because look, it's 200 pounds of rice and only a couple ounces of marijuana. Is that fair? Is that really the law that we're trying to make here, the rule we want to write?
Your Honor, it'd be different from your example between the case we have at hand. In your example, the marijuana is completely concealed and not a part of the rice that would be mixed with. In our case, the THC was within the chocolate, therefore it cannot be weighed the same as the drug. To call the chocolate a part of the drug involved leads to an absurd result. When a statute is ambiguous, as in this case, it has long been held that it is up to the court to avoid any interpretation that leads to an absurd result. In the Ohio Supreme Court case, Gonzalez 1, when the court considered a statute very similar to the one today, they ruled that you have to exclude the weight of the filler to charge the defendant of the crime. However, not even a year later, the same judges reversed their previous holding, saying that you did have to include the weight of the filler. The court in Gonzalez cases would like us to believe that the statute they used was clear and unambiguous, but clearly that notion is false. In fact, it is clearly false because there was two completely different holdings from the exact same fact pattern, the exact same statutes, and the same exact judges. The only thing that is clear about the Gonzalez cases is that the statute they were using was ambiguous. This is where the ambiguity doctrine becomes relevant today. As I stated, the statute in Gonzalez were similar to the statute today. Therefore, when faced with ambiguity, it is up to this court to review each interpretation separately to avoid an absurd result. Further, it is clear that the legislature, when crafting the statute for marijuana, was primarily concerned with THC. If you look back at the definition of hemp, it states no more than 0.3% of THC. The reason the definition of hemp is present in the statute is to help regulate marijuana. From the definition of hemp provided, it's clear that the legislature was only concerned about THC. If anyone possesses any THC levels under the 0.3% of dry weight defined under the hemp definition is entirely decriminalized.
So are you saying then that someone could take these chocolates, which are admittedly marijuana edibles, 10 milligrams apiece, designed to get people high, and because they're not regulated and because they're not prohibited, they could sell them anywhere to anyone in the state of Buckeye?
The statute to define that makes it a hemp product, we do not deal with what the chocolates were intended for. I mean, a hemp product can be lotion, that would still equal a hemp product. So we only have to know if someone would use these to get high.
How do you square that conclusion with the fact that in the medical marijuana provisions of the Buckeye state law, they talk about and in fact regulate edibles? Are these not marijuana edibles?
No, Your Honor, because they have the THC level that makes it hemp. Taken together, it is clear that the statute we are dealing with today is primarily only concerned about THC. To say that possession of chocolate, even in close proximity to marijuana, is in violation of the statute and makes it absurd. Remember, the state's interpretation offered today would charge two people with the same exact charge when one person possessed 1,000 grams of marijuana and 1 gram of chocolate, the same as someone who possessed 1,000 grams of chocolate and only 1 gram of THC. The state claims that by combining 2.5 grams of THC with over 1,000 grams of chocolate, as in our case today, it constitutes a felony of the 3rd degree. Clearly an absurd result. No matter how much—
Counsel, you mentioned that the judges were the same in Gonzalez 1 and 2. Are you sure about that?
Your
The
Honor,
reason I ask is I wasn't on Gonzalez 1, but I did write part of Gonzalez 2.
I'm sorry, I misspoke about that section.
Thank you.
No matter how much chocolate you add to 2.5 grams of THC, it never changes the level of THC concentration found inside the chocolate. The state comes before the court today attempting to convict a man of a 3rd degree felony for possession of chocolate. In fact, Your Honors, adding chocolate to the THC lessens the danger. Take alcohol, for example. When you drink alcohol on an empty stomach, it takes significantly less alcohol to make you drunk. Whereas if you were to consume alcohol on a full stomach, it would take a lot more alcohol for you to feel the effects of alcohol. This is the
Counsel,
same—
you don't have personal experience of that, do you?
I do not, Your Honor.
Thank you.
This is the same concept we are dealing with today. If you possess 2.5 grams of pure THC, it would be very simple to consume the THC. However, by diluting the 2.5 grams of THC with 1,122.5 grams of chocolate, you significantly increase the amount of product you would have to consume in order to feel the same effects. And it would increase the time and effort it would take to consume all the THC. It is clearly absurd to increase the level of chocolate from a minor misdemeanor to a 3rd degree felony simply because the THC was mixed with a large amount of chocolate. It is for these reasons we respectfully request that the court rules in favor of the defense and finds that Jones was only in possession of 2.5 grams of hemp and was improperly charged. Thank you.
Thank you. Any other questions before she steps down? Thank you very much. Respondent?
Yes, Your Honor. May I proceed?
Please.
Good afternoon. My name is Sylvia Corson, and before my time begins, I'd just like to confirm that my student code is D3, and I will be addressing the constitutional issue for the respondent. My co-counsel, Hannah Madison, student code D4, will be addressing the statutory issue. Chief Justice Fisher, may it please the court. It is our position that the search of the car that Austin Jones was driving, as well as the trunk and the container within the trunk, was constitutional under the Fourth Amendment. We respectfully request that you affirm the lower court's decision. The lower court correctly determined that Jones's Fourth Amendment rights were not violated for two reasons. First, the officers had probable cause to search the car, and second, that probable cause justifies the scope of the search. To my first point, there was probable cause for officers to search the car that Jones was driving. The Fourth Amendment to the United States and the Buckeye Constitution protects individuals against unreasonable searches and seizures, and says that warrants may only be issued if there is probable cause. However, in 1925, in the case U.S. v. Carroll, the United States Supreme Court laid out the automobile exception, explaining that due to the transient nature of automobiles, it's not always practical for officers to wait around to get a warrant while the car that they want to search can just drive away.
In the modern era, it's a lot easier for the police officer to get a warrant, isn't it? They can call on FaceTime or Zoom, speak to a magistrate.
Yes, Your Honor.
So maybe we should get rid of that.
While it is easier to get a warrant in modern times, a car could still drive away while a police officer is on the phone trying to get that warrant, especially if that car does have illegal contraband in it. It can just drive away while the police officer is on the phone trying to get a warrant, which is why it's so important for the automobile exception to be in effect, so that if officers have probable cause to believe that there is illegal contraband within a car, they may search that car without a warrant.
Going further with Justice Fisher's questions, these are old cases that you are relying on, especially Carroll, but even, is it Morris? The 1990 case, in the post-legalization of medical marijuana era, does it really make any sense at this point? Do these cases make sense?
Yes, Your Honor. And Carroll does not deal specifically with the scent of marijuana, but
Of course not.
even with the medical marijuana being legal in some states, the odor of marijuana is still sufficient to establish probable cause for officers to search a car without a warrant.
Do you have cases to rely on for that proposition?
Yes, Your Honor. Now, opposing counsel cited to Pennsylvania v. Barr and other cases, but it's important to consider the difference in the facts between Pennsylvania v. Barr and the facts of the case before this court today. Specifically, in Pennsylvania v. Barr, which is a persuasive case but not binding, the defendants immediately produced medical marijuana licenses showing the officers that they could legally obtain marijuana for medical reasons.
But this officer never asked whether they had a medical marijuana license.
That is correct, Your Honor. However, there's nothing in the case law to suggest that the responsibility would fall solely on the officers to ask if the defendant has a medical marijuana license before searching the car. They informed Jones that they would be searching the car based on the scent of marijuana, so he knew what the reason for the search was. And at that time, if he had a medical marijuana license, which there is nothing in the facts to indicate that he did, he could have produced that and shown it to the officers, much like the defendants in Pennsylvania v. Barr, but Jones did not.
So is the rule you would like us to craft that in the event someone's pulled over and the officers indicate, which they don't have to do, that they're searching because of a scent, that it is then the burden of the person who has been stopped to produce a license saying, I know you smell marijuana, but look, see, I'm allowed to have it?
No, Your Honor, there is no case law to indicate which way it should be or who the responsibility falls on. The officers may ask, or the person may produce that license if they would like to show the officers that they do have a medical reason for having marijuana. But it's also important to consider, and opposing counsel cited cases like Massachusetts v. Overmeyer, but in that case, the officers smelled raw marijuana, which is different from what the officers smelled in this case. And under Buckeye's medical marijuana statute, there are different legal ways that marijuana may be had and consumed. People can have plant matter, they can consume it in edibles, they can even vape it, but none of these ways would leave behind the same overwhelming stench of stale marijuana that was smelled by the officers in this case.
If he was looking for burning marijuana, though, why would he open a pinata? Wouldn't it have been on fire?
Well, Your Honor, in this case, as per the stipulated facts, the scent was from smoking sessions long past. So while it was still a very strong scent coming from the car, it was of burnt and not currently burning marijuana.
The defendant knew that, but the officer wouldn't have known that.
Yes, well, again, it has been stipulated in the facts that that is what the officers smelled, and the officers may have been able to tell the difference between how stale the scent was, but because this scent was an older scent and it was specifically the scent of burnt and not currently burning marijuana, that indicates that marijuana had been smoked so frequently in the car that it made the entire car smell this strongly of marijuana that officers could smell it, even just with the slightest change of the wind, which would give officers probable cause to believe that that stash of marijuana that was being smoked so frequently could be hidden anywhere in the car, including in the pinata. And we can look to the United States Supreme Court ruling in U.S. v. Ross, where the Supreme Court held that the scope of a warrantless search of an automobile is not defined by the nature of the container in which the contraband is secreted. Rather, it is defined by the object of the search and the places in which there is probable cause to believe that it may be found. In this case, the officers would have probable cause to believe that this stash of marijuana may be found not just in the passenger compartment of the vehicle, but also possibly in the trunk, and even maybe hidden or concealed inside the pinata. And opposing counsel also mentioned California v. Acevedo and the difference between the scent of legally vaped marijuana versus illegally smoked marijuana, which even under Buckeye's medical marijuana statute, smoking marijuana is still illegal. However, vaping marijuana means that it is vaporized, so the scent would not linger for very long. It would evaporate quickly. So even if what the officers did smell was vaped marijuana, that would mean that Jones had been recently vaping marijuana and therefore may be driving impaired and under the influence of marijuana. So
Let's say he was driving impaired. Let's say they have probable cause to believe that. Why would they then get to search the car? They're not going to find more evidence that he's driving impaired by looking at compartments in the car, right?
Yes, Your Honor, but if he was driving erratically and if he seemed as though he was under the influence of marijuana, then the officers would have probable cause to believe that there may be evidence of that within the car and search the car because...
But we don't have any erratic driving, right?
Well, he was originally pulled over for running a stop sign, and...
That's not necessarily erratic driving, is it?
It's not. We do agree
On my
that
way
that's-
up here today, there's a lot of people doing it.
Yes, we do agree that that is not erratic driving, but in the event that there were other indicators that
But we don't
he
have that
was-
here.
We do not have that in this
All we
case,
got
Your
is
Honor.
the smell.
That's correct.
Thank you.
But the smell alone is sufficient to establish probable cause for the officers to search the vehicle. Also looking at California v. Acevedo, in which the United States Supreme Court re-examined the decision in Sanders and held that there would no longer be a distinction between searching a car that happens to have a container in it and searching a car because there is a container in it that needs to be searched.
You haven't mentioned the fact that this was a borrowed car, and I'm considering the case of Byrd versus United States that holds that drivers of rental cars have even more rights, have maybe an extended right of privacy. How is this any different?
Yes, Your Honor. So in the case of Byrd v. United States, it dealt with someone who was driving a rental car who was not listed on the rental agreement, and the court did hold that Byrd had an expectation of privacy inside the rental car based on the right to exclude. And while Jones was driving a car that he had borrowed from a friend, that means that he did have some expectation of privacy, meaning that Jones has a right to challenge the search of the car, but not necessarily that the search was unconstitutional. Opposing counsel also mentioned the case of Michigan v. Armstrong, but that case is notably different from the facts of this case today. In Michigan v. Armstrong, it dealt with the initial approaching of the car by officers simply because they smelled marijuana. But in this case, officers had already pulled Jones over because he ran a stop sign, and it was while speaking with him at that point that they smelled marijuana and decided to search the car based on the probable cause established by that odor that Jones may have had marijuana in the car. And going back again to United States v. Ross, where the Supreme Court held that if probable cause justifies the search of a lawfully stopped vehicle, it justifies the search of every part of the vehicle and its contents that may conceal the object of the search. So in this case, the officers had probable cause based on the smell of marijuana to believe that Jones may have marijuana or some illegal contraband inside his vehicle. So they had probable cause to search not just the passenger compartment, but also the trunk and any contents that may conceal the object of the search. So in this case, the pinata.
So is the state's view that because this car smells bad, admittedly as a result of possibly long past conduct, that anyone driving this car who gets stopped is going to be subject to search when the police officer comes up and smells the car?
Well, yes, Your Honor, because there's no way for the police officers to know exactly how that scent of marijuana got into the car, whether it was the person who owns the car or whether it was the person who was driving the car, what the car was being used for.
But doesn't the smell of stale smoke, rather than indicate the current presence of marijuana, in fact indicate that whatever marijuana there was is now up in smoke?
Well, yes, Your Honor, it indicates that marijuana has been smoked in the car, which is illegal to smoke marijuana, and that this illegal activity has been done frequently enough to make the entire car smell like marijuana smoke. And because this illegal activity has been done so frequently inside the car, this would give the officers probable cause that there may be evidence of that illegal frequent activity inside the car, and so they would have probable cause to search for the stash of marijuana, which may have been hidden or concealed in any part of the car, based on the decisions of the U.S. Supreme Court in both U.S. v. Ross and California v. Acevedo, which, as I mentioned earlier, re-examined the decision in Sanders and held that if there is probable cause to search a car, then there is probable cause to search every part of that car for anything that may be concealing the object of the search. So,
But what we have here is a container within a container, right? We have a pinata inside the trunk. Isn't that a
yes.
container? Is there case law on a container inside a container?
Well, there is case law, Your Honor, on a container inside the trunk of a car, such as the pinata. I see that my time is expired.
Please finish.
Okay, thank you. Such as the pinata in today's case, and looking to California v. Acevedo, which dealt with a similar situation, the U.S. Supreme Court still ruled that there was probable cause justifying the search of every part of the car. And so it is for these reasons we ask that you affirm the decision of the lower court.
Thank you. Counsel, please proceed.
Good afternoon. My name is Hannah Madison, and before my time begins, I would like to confirm that my student code is D4, and I will be arguing the second issue for the respondent. Chief Justice Fisher, may it please the court. Buckeye Code 292511 was properly interpreted and applied by the 14th District Court of Appeals. The trial court determined, and the appellate court affirmed, that Austin Jones possessed over 1,000 grams of marijuana and was properly indicted for a third-degree felony. We ask that you affirm these rulings. As the Ohio Supreme Court stated in Gonzalez 1, if the language of a statute is clear and unambiguous, we must apply it as written. That court further stated that it is the duty of the court to give effect to the language of the words used, not to delete words used or to insert words not used. These are the principles of statutory interpretation that we will apply today. Now, counsel for the petitioner asks that you consider only the actual weight of the marijuana within the chocolates for sentencing under BC 292511C. However, if we look to the plain language of that statute, it states that if the drug involved in the violation is marijuana or a compound, mixture, preparation, or substance containing marijuana other than hashish, whoever violates Division A of this section is guilty of possession of marijuana. Now that's
Arguing that that statute means that the fact that there was only 2% or less than 2% marijuana in each of these chocolates makes the whole amount of the weight of that chocolate part of the crime?
Well, Your Honor, in this case, we have 250 individual chocolates, each weighing 4.5 grams, with 10 milligrams of THC in every single chocolate. And as this plain language of the statute says that we have to prosecute compounds, mixtures, preparations, or substances containing marijuana, that would include a product like this, where the THC has been mixed in and is now a part of the product.
So you want the court to consider the weight of the entire product versus just the weight of the marijuana that may be contained within that product?
Yes, Your Honor, that is what the statute requires.
Doesn't that lead to an absurd result, though? That if this THC were merely in the form of marijuana leaves, the crime would have it might be a misdemeanor, it might be a lower degree of a criminal charge.
Well, Your Honor, if we look to the logic used in Gonzalez, we can see that the THC is part of the usable drug. And the purpose is to get whoever's using it high or get a buzz, as you mentioned earlier. In Gonzalez, the Ohio Supreme Court held that we have to...
Gonzalez 1 or 2?
Gonzalez 2, Your Honor.
Thank you.
They held that you have to use the entire compound, mixture, preparation, or substance, including any fillers that are part of the usable drug.
Okay, but Gonzalez is about cocaine. And isn't it true here that the definition of drug excludes food? And here we have marijuana mixed with food. So how can we say that the mixture preparation language trumps the fact that elsewhere drug is defined so as to exclude food?
Well, Your Honor, if we look to Gonzalez 1, where they lay out the statutory interpretation rules, one rule that they focus on is that the court's main objective is to determine and give effect to legislative intent. So we can look to that statute where it excludes food from the definition of drug and see what the intent is. So BC 472901 states that a drug is any article other than food intended to affect the structure or any function of the body of humans or animals. The intent of this statute is to keep plain food products from being illegal. And it could be said that any food could affect the structure or function of your body. I mean, I'm lactose intolerant, so like if I were to have milk, that would certainly affect the functions of my body. And under
So
this
if this was milk chocolate, you couldn't have it.
That's true, Your Honor. Also, it has THC, so I would hope I wouldn't. So under that statute, if we were to not have the food exception, we could say that milk is considered a drug. That is why that language is there. It isn't there to protect products that have been laced with illegal substances like THC. The products then take on a new function. They're not there to provide nourishment like the definition of food provides from Merriam-Webster.
Chocolate doesn't provide much nourishment to start out with, does it?
No, Your Honor. However, it is societally considered as qualifying as food. If we
My
look
grandkids would agree with that.
So the language of that statute is not to protect food like the chocolates in this case that have been laced with THC. And counsel did mention that the food can be excluded and we can't consider it as part of the drug. However, BC 379606, the statute about medical marijuana, does concede that food can be used as a drug in the form of edibles, which is what we're dealing with in this case.
How do you reconcile the exclusion of hemp?
Well, Your Honor, counsel did bring up the hemp argument and stated that these chocolates have a THC concentration of less than 0.3% and should qualify under BC 92801C. However, there are two qualifications for something to be considered a hemp product, and they only considered one of those qualifications. It's true that in the hemp product statute, the language states that it is any product with a THC concentration of less than 0.3%. However, that is the THC concentration combined with any fillers that are in the product. It's the concentration of THC in regards to the product. The other qualification in the same statute, in that same sentence, in fact, says that that product must be made with hemp. Hemp, not all THC qualifies as hemp. In fact, if we look to the earlier language of that statute, BC 92801C, hemp is defined as the plant Cannabis sativa L. This is a specific strain of cannabis. Not all cannabis can be grown in the same way, as this specific strain produces THC that has a lower concentration. It qualifies under the statute as having not more than 0.3% to qualify as hemp. And you have to use a dry weight basis for the determination of whether or not THC qualifies as hemp, not a hemp product. And when we use the dry weight basis, separating the THC from the fillers to determine if it's hemp, we find that it is 100% THC. In fact, this is backed up by the stipulated facts that counsel relied on for their determinations of the amount in each product. The stipulated facts state that this product contains cannabis, not Cannabis sativa L, the plant that creates hemp. It also states that these chocolates were made with THC. They don't state that they were made with hemp-derived THC. Therefore, we cannot just assume that the concentration of the THC that was used in the chocolates is less than 0.3% and qualifies as hemp. We can't simply qualify these products as a hemp product. Otherwise, that would be setting the precedent that if you were to take marijuana and add it into any amount of chocolate that would lead to it having a less than 0.3%, that marijuana would automatically become hemp. That would be an absurd result, Your Honors.
Well, it doesn't say in the record, does it, from what particular genus of cannabis the THC used in these chocolates was derived?
That's correct, Your Honor.
And the prosecution bears the burden of proving their case, do they not?
That's correct.
So
They did no lab work to see whether or not the THC used was or was not hemp, and therefore we have to rely on the stipulated facts to where there is no dispute, where it states that the products contain cannabis. It doesn't say that specific strain of cannabis sativa L, therefore we just have to assume that it is straight THC within a 100% concentration, which disqualifies it from the hemp product statute. Now, if we look back to Gonzalez 2, that just further backs up the point that we can include the food in our determination of the offense level. In Gonzalez, you had baggies of cocaine that were mixed with an unknown amount of fillers. However, those fillers were not meant to be separated out before consumption. And even though we're dealing with marijuana here, the same is true of the fillers in relation to the drug. You're not going to melt down your chocolate and try to retrieve THC oil, if that were even possible, before you're going to consume it. They are meant to be eaten as a whole. In fact, the instructions on the package even say eat. They don't say separate out the THC and eat that alone.
What do you say to your friends on the other side's observation that your argument treats someone who has 1 gram of marijuana and 1,000 grams of chocolate all smushed together the same as someone who has 1,000 grams of marijuana and 1 gram of chocolate all smushed together?
Well, Your Honor, in this case, we don't have that issue because the ratio is 10 milligrams to 4.5 grams. However, if it were to get into the territory where you had such a small amount of THC in relation to a large amount of chocolate, we would hope that prosecutors would use reasonable thinking to state that they shouldn't be prosecuting such a small amount of THC. And so we could avoid an absurd result by interpreting it in that way. The idea that we should include any fillers in our determination of the offense level is also backed up by another persuasive case from the Ohio Supreme Court in Ohio v. Pendleton. Now, in that case, there was a puck containing a mixture of fentanyl and heroin, and while they knew the amounts of both, they did hold that you could use the amount of fentanyl as a filler to hold that the entire product did constitute heroin and was charged as being 139 grams of heroin.
Can you explain to me the difference between fillers and fillers? You know, say fillers in cocaine presumably have no nutritional value. The filler in this case would be chocolate, and it might have some nutritional value. What's the difference?
Well, Your Honor, while it's true that the fillers typically used in cocaine aren't a normal food or drink that one would have on their own, they can be things like baby formula or cornstarch. The fillers are still part of the usable drug. Like, you wouldn't separate them out, like I mentioned earlier. You're gonna ingest the cocaine as a whole, and you're going to eat the chocolates as a whole. So the similarity is that you're not trying to separate these drugs, the drug from the filler, before you're taking it. So you have to charge it as a whole weight.
So would it have made any difference if the THC had been in a sort of jelly shot?
Well, Your Honor, if it was still meant to be ingested as a whole, the calculation would still be the same, and you would have to use the total weight. Now, opposing counsel may argue that if we use the actual weight for determining whether or not it qualifies as hemp, that 100% concentration of the THC by itself, then we would also need to use the actual weight when determining the offense level. However, I would like to make it clear that the hemp statute and BC 292511 are completely separate statutes that serve completely different purposes. Only the hemp statute includes the specification of a dry weight basis, where you remove the fillers and use only the weight of the actual THC. And if we look back to the rules of statutory interpretation, it is the duty of this court to give effect to the words used, not to delete words used or to insert words not used. If we were to use the dry weight basis to determine the offense level, we would be inserting that specification of a dry weight basis into BC 292511C. If the legislative intent of the General Assembly was to have us use the actual weight of the drug aside from the chocolate in determining the offense level, they would have included that specification. It is not this court's place to insert that and use the actual weight of the THC to lower the offense level. It is our position that under the plain language of the statutes, the lower court's decision to charge Jones with a third-degree felony was correct. Since Jones possessed 250 chocolate products that each weighed 4.5 grams, and the statutes require us to consider the total weight of a compound, mixture, preparation, or substance containing marijuana, Jones was in possession of 1,125 grams of marijuana, meeting the requirements under BC 292511, subsection C3D, for a third-degree felony. We respectfully request that you affirm the decision of the lower court.
Counsel, before you sit down, I want to go back to Pendleton for a second. You're talking about a puck. Assume for me the law says you need 50 grams, which would be terrible, but 50 grams of fentanyl for a F3, felony third, and you needed 75 grams of cocaine. And in the puck, you have 60 grams of cocaine and 40 grams of fentanyl. Could you charge them for both?
Your Honor, I believe that was the issue in Pendleton.
It
They
is.
had two separate amounts, and it was a double jeopardy case. So they were deciding whether or not they could use both amounts.
What did they say?
Well, in the end, they decided that you couldn't use both amounts. However, you could use one amount as the filler for the other to prosecute one of those drugs.
One time.
Yes, Your Honor.
Thank you.
We respectfully request that you affirm the decision of the lower court. Thank you.
Rebuttal? How much time? Three left. Okay. Three. Please proceed.
Thank you, Your Honor. Chief Justice, may it please the court. Opposing counsel argues that the search of Austin Jones' vehicle was within the scope of the automobile exception. And as opposing counsel stated, Acevedo held that the scope of a warrantless search of an automobile is defined by the object of the search and the places in which there is probable cause to believe that it may be found. The object of the search was burning marijuana. And in order for the object of the search to be found within the pinata, within the trunk of the car, Austin Jones would have had to exit the vehicle, go to the trunk, open the pinata, place the burning marijuana inside the pinata, reseal the pinata, since the facts of the case stipulate that the officer physically had to tear open the pinata to search inside of it, close the trunk, walk back to the front of the vehicle, and return to the driver's seat.
Counsel, but at the time that the officer is doing that search, he doesn't know the extent of the seal in the trunk. I mean, he's smelling it, he's going to look for what he can find. So I feel like that's a little bit of hindsight now, but the officer at the time didn't know he was going to be going to a sealed pinata in the trunk. He was looking for the marijuana that he smelled, right?
Exactly. And once he moved to the trunk and only saw a pinata within the trunk, that is where the search should have stopped, assuming arguendo that he even had probable cause to search the trunk in the first place. The only factor that the officer used to search the vehicle was the smell of burning marijuana. So pursuant to the Supreme Court in Acevedo, if that was the object of the search, the officer would have had to conclude that the burning marijuana, which could produce a fire hazard, was within the sealed pinata in the trunk. And it's unreasonable to conclude that Jones would have been able to somehow place the burning marijuana within the pinata without being noticed by not one, but two police officers in broad daylight during the traffic stop. Now, while we understand that in the case of Pennsylvania v. Barr, a medical marijuana card was produced, in cases such as Massachusetts v. Overmeyer, Ohio v. Ferris, Ohio v. Ulmer, and Michigan v. Armstrong, this is not the case. In all of these cases held that the smell of marijuana does not constitute probable cause. Now, briefly addressing the statutory question, under Buckeye Code 2925.11, what we have to weigh is the drug involved. And the definition of drug excludes food from being a drug. Therefore, it cannot be weighed to charge Jones. We have to look at the statutory intent only. And when we deal with an ambiguous statute, the definition of drug is clear. The food is excluded and no intent is needed. It is for these reasons we respectfully request that you rule in favor of the appellant. Thank you.
Thank you all.
Wow, that was incredible and so much fun to watch. Congratulations to all of you. Our judges will now have a few minutes to finalize and submit their score sheets before giving some feedback. While judges give their feedback, OCLRE staff will take that time to tally ballots and determine the winner. We are going to hold an awards ceremony at 4:45 p.m. immediately following the tally. So teams and judges, if you wish, please hang tight and I will return momentarily. Thank you.
Folks, wow, that's all I can say. You've answered a lot of questions that I've had this morning during the preliminary rounds, and you answered them very, very well. A few specific comments. Hannah, I was very impressed by your knowledge of the species of marijuana here. But yeah, seriously, that was the first time I've heard that, at least that I can recall hearing that today. And it's just, as you said, the facts are silent, so we have to assume that it is marijuana and it's not the hemp species. It also occurred to me that you high school students had to discuss a number of substances that not only are illegal for you at this point in time, but that in most cases are illegal for the rest of us in this room at this point. And Minda, I really enjoyed on your rebuttal the analogy that you were discussing about tearing open the pinata. It was a very interesting argument, and I wanted to hear more. There was an intervening question, but I wanted, because that has been bothering me all day, just why the officer tore the thing open, why they had any reason to believe that burning, a smell of burning marijuana would come from this paper mache object that arguably should have been on fire.
Yeah. No. Paul?
I get just blown away by the ability that you four showed today. The oratorical skill is just fantastic. You've got to be, and your teachers and parents have got to be enormously proud of you. And if they aren't, they should be, because you did a tremendous job, all four of you. And trying to separate a point here and a point here is almost really unfortunate, because it's very hard. And I want to congratulate the four of you. You did a fantastic job, and you were really great.
Yes, I will agree, and as the only female up here, very proud to see four females out there. And yeah, you ladies knew the facts of this case, you knew the cases, you were able to distinguish and respond to what your opposing counsel argued, and that's always great, is to be able to say, you know, well, they pointed to this, but let me tell you why it doesn't apply, and just be able to go through, you know, what your opposition, either what you anticipate they're going to argue or what they have argued, and specifically responding to, you heard them say this, and, you know, let me tell you why that's not relevant here, and then responding on rebuttal. That's a great job. And just being able to, you know the cases so well that you can distinguish them. And sometimes the way you distinguish it is maybe very small or not that significant, but the fact that there's something to distinguish it, you know, allows us to not feel like we're so bound by it, or the fact that it's from a different state and, and why we should still rely on it or why we shouldn't and that sort of thing. And just understanding the precedential value of those cases, you clearly showed us that you knew and understood that. So very impressed, ladies. Great job. Hopefully you continue wanting to be a lawyer, or if not, you're just going to make your spouse probably very angry someday because you're very good at arguing. So.
Ben?
Well, yes. Goodness me, how fantastic. What a wonderful job you all have done. I mean, far better, without insulting the bar of this state, far better, I think, than many actual lawyers would have done with these facts. I mean, just marvelous. When I dreamed up this fact pattern, I did my best to think it through and think of all the different things that people could argue, both spurious and accurate. And even despite that, you guys today have surprised me in all sorts of ways with what you've argued and convinced me of things that I did not think I was capable of being convinced of. And just really, really phenomenal. One point of law I would draw your attention to regarding the search. It is a probable cause search, so one does not want to get confused between a probable cause search, which would allow you to search the vehicle and all the containers in it, with a search incident to arrest, where you would get to search the area, the grab area of the person being arrested from within the car. So just something to think about as you move forward in your legal journeys. But wow, all I can say is wow, just fantastic.
Before I begin, a couple things. First, a round of applause for Ben and the entire OCLR team that brought this all together. Second, as Mr. Tracy said, you did better than many lawyers would have done under the same circumstances. I purposefully throw in some humor, no, on purpose, because that tends to get people off track. But all four of you came back on, and that's very important. And who had the Gonzalez 1 and 2? Was that you? Nobody else here would know. I would know. Just that was an interesting situation because actually, wasn't it like a couple months? Yeah. Right. And we came on the bench. I dissented from taking the case on reconsideration, but I concurred in the majority opinion. So that was my first dissent also. It's a very interesting issue, isn't it? Right? All of you are very good. Somebody said your husbands, spouses, partners, whatever. I pray for them. It's bad enough being the guy, but you don't win many discussions with. I don't win many discussions with my wife to start out with, but you four have great ability, and I hope you do become lawyers. And everybody else in the audience, the state, we've got enough lawyers in the urban areas, but we actually have jobs available throughout the rural areas. And you can make a great living, low cost too, low cost of living in the rural areas of Ohio. And we have programs that we pay for, the state bar does, to put you, when you're in law school during the summers, in those rural areas. So whether you're these four or any of the others, please keep that in mind. I want to say that all four of you were excellent in coming back, not just when I was humorous, but from my questions or any of the questions of the others, getting back to where you were is very important. Because during court, oral argument, you may get asked a question. I mean, you all had your own, the constitutional issue and the statutory thing. But most of the time you're up there by yourself and you're arguing both. And you may want to start out and you think I got this great constitutional argument, but all they want to do is ask about is the statutory one or vice versa. So being able to respond to the question and then get back to your argument is the sign of a quintessential good lawyer. Yes. And you all four could do that. And thus you all should be very proud of your exploits here today. Thank you for being here.
Congratulations again on competing in the 2023 Moot Court State Competition. Please join me as we thank our 5 judges for their time today. Judges, if you're okay with it, we would like to dismiss you at this time for a group picture out in the lobby with our associate Caleb. Thank you for your service. Congratulations again on competing today. Moot Court is a very rigorous program, so everyone here should be proud of what they have achieved. Please give these 4 lovely students a round of applause. Next, I'd like to make sure we thank several people and groups for making this competition possible. First, thank you to our teachers and our advisors. Your guidance and support are invaluable. Thank you to the volunteers who judged today or evaluated briefs. We could not do this program without you. Thank you to the Ohio Channel for filming our championship round. And finally, thank you to the OCLRE sponsors, the Supreme Court of Ohio, the Office of the Ohio Attorney General, the Ohio State Bar Association, and the ACLU of Ohio Foundation. In addition, thank you to the Ohio State Bar Foundation for their financial support of the program. With that, we have several teams and individuals to recognize for their achievements in the Moot Court program today. First, I want to acknowledge our 2 semifinalist teams and their students. Congratulations to Upper Arlington Team Harlan. If you're still here, please come forward and accept your plaque. Also, congratulations to Mason High School Team Tangerines. Is Mason still here? Okay, we'll send them their plaque later. Congratulations, Upper Arlington, and as well as Mason High School. Next, I will recognize individual students for our Outstanding Advocate Awards. Congratulations to the following. 3rd place, Best Advocate Petitioner, goes to Hannah Madison. Third place, Best Advocate Respondent, goes to Minda Bates. Second place, Best Advocate Petition. Second place, Best Advocate Respondent, goes to Sylvia Corson. First place, Best Advocate Petitioner, goes to Minda Bates. And finally, first place, Best Advocate Respondent, goes to Hannah Madison. Finally, we have 2 extremely talented teams before us today in the championship round, both of which deserve our full acknowledgement. We have Danville High School Team Blue, which includes Minda Bates, Nora Holbrook, and Ryan Lucas. Also in the final round is Springfield High School Team Wild, which includes Lisa Wheeler, Hannah Madison, Sylvia Corson, and Sarah Hallmark. Congratulations to both teams on your hard work, preparation, and performance. Now let's announce the competition winner. The 2023 Moot Court State Champion is Springfield High School. And again, due recognition and congratulations to our 2023 Moot Court State runner-up, Danville High School Team Blue. Congratulations again to everyone. Have a wonderful evening and safe travels back home. And we hope to see you back in 2024. Thank you.